Turn now to a story we told you about just a few minutes ago. Charlie Sheen opened up about his HIV status in a national TV interview, and it could be opening doors to some legal problems for Sheen. And joining us now to talk about this, attorney Daliah Saper. And Daliah, it's good to see you as always. What kind of trouble is he in if he actually did know that he had HIV and was with all these partners? What kind of a legal hurdle does he face?
I'm pretty sure that he's in trouble already, and that's why he's finally come out with the announcement. There's reports that he's bought off many of his previous sexual partners, trying to keep them quiet about this news. But generally, anyone who's knowingly infected a partner with HIV or communicable disease that's not curable can be subject to both criminal and civil lawsuits. Okay,
and what is the specific legal test in California?
Well, in California, like any other state, they will have different classifications. And typically, if you are using your disease as a weapon and you with specific knowledge intend to infect another person, that could be a felony, and you can go to jail for, prison for a long, long time.
In situations like this, as I understand it, typically it's a civil suit that comes up?
Usually it's not worth the state attorney's time to prosecute these cases. So most infected individuals will pursue a civil claim, and the causes of action typically look like intentional infliction of emotional distress. You engage in a civil battery. It was negligent of you to not know, or you were reckless in giving me the disease.
Here's what Charlie Sheen is saying in this interview today about this situation. He says, the two people I had unprotected sex with were under the care of my doctor and were completely warned ahead of time. So, in a way, he's trying to suggest that that takes him off the hook, right?
It actually is an affirmative defense. If you give consent to the individual after you've been informed of the disease, then you can't sue.
So, what is the precedent here in terms of what sort of jail sentence could possibly be associated with this, if in fact it comes to this?
Well, Illinois, it's a Class 2 felony. So you can go to jail for 3 to 7 years, and if there's aggravating circumstances, that number can go up to 14 years. So it's a very serious crime, and those who are reckless with their activities can be subject to not only social disgrace, but also criminal penalties as well, civil lawsuits.
Very good. Daliah, thanks for shedding some light on a very complicated and controversial topic this morning.
You're very welcome.
All right.